It's Ziegler, isn't it?
Ziegler.
It is Ziegler. All right. This is case number 25-4964 SM. We're here for a pretrial. Mr. Carnes, is there any resolution in this matter?
Yes, Your Honor. It's my understanding that Ms. Ziegler will plead guilty as charged. The people are recommending, and the defendant agrees, that she be placed on a delay of sentence for 6 months. And if she's successful during that period of delay, that the people would dismiss the case in full.
All right. Ms. Ziegler, is that how you wish to resolve the case?
Yes, sir.
And is that your understanding of what the plea agreement is?
Yes, sir.
Now, do you also understand that that sentence agreement that you have, the delay with the dismissal, that's an agreement you have with the prosecutor, not an agreement you have with me. So if I decide that I'm not going to go along with that, you'd be able to withdraw your plea. Do you understand that? Will you please raise your right hand? Do you solemnly swear or affirm this testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. So it's my understanding that you'll be pleading guilty as charged to retail fraud 3rd degree. There's the agreement that you would be placed on the delay of sentence for 6 months. And if you're successful with the terms of that delay, the charge would be dismissed.
Yes.
Now, I want you to understand that during that 6 month, if I go along with that, it will show that you were convicted of a retail fraud 3rd. Do you understand that?
Yes, sir.
Back on, and I'm sorry, so the retail fraud 3rd is a misdemeanor punishable by up to 93 days in jail and or a fine of $500 or 3 times the value of the property taken. Back on November 25th of this year, were you on probation or parole?
No.
Were you on bond?
No.
So I've just been handed a note that you haven't been fingerprinted yet. Why is that?
I didn't have a vehicle until Sunday. I have an appointment tomorrow at 4 p.m. to go get fingerprinted.
All right. Do you remember reading and signing the advice of rights form in this case that talked about your rights to a trial and your rights to an attorney?
Yes, sir.
Did you understand those rights?
Yes, sir.
Most importantly, do you understand that you have a right to a jury trial, and that by entering a guilty plea today, you'll be giving up that right and you won't have a trial of any kind?
Yes, sir.
Other than the agreement, has anybody promised you anything in order to get you to plea?
No.
Has anybody threatened you in any way?
No.
And is it your own free choice to plead?
Yes.
Mr. Carnes, are you aware of any other promises, threats, or inducements?
No, Your Honor.
Then Ms. Ziegler, to the allegation that on or about November 25th, 2025 in Herring Township of Wexford County, how do you plead to retail fraud 3rd degree?
Guilty.
In order to accept that plea, I must have you tell me what it is that makes you guilty. So back on November 25th, were you at, looks like Walmart in Herring Township?
Yes.
And while you were there, did you take or attempt to take some property that belonged to the store without paying for it?
Yes.
And what is it that you either took or tried to take?
I don't even remember everything. I know that it was some stuff to do with Thanksgiving, like the throwaway pans, just like extra stuff.
Okay.
And I also took some feminine pads that they actually let me go in and pay for after the fact.
All right. Do you believe that the items taken would have had a value of less than $200?
Yes, I believe it was 70. I think that's what we calculated when I was there with the loss prevention team.
Okay. All right. And was it your intent to take the items without paying for them?
No. Well, yes, I did.
Okay. All right. Mr. Carnes, you believe the defendants provided the factual basis to accept the plea and the court rules have been complied with?
Yes, Your Honor.
As does the court, I find the plea is knowing, voluntary, and accurate. Ms. Ziegler, I find you guilty of retail fraud 3rd degree. Any allocution, Mr. Carnes?
Yes, Your Honor. The state police report does state that Ms. Ziegler was cooperative with loss prevention. I looked at her criminal history and showed one driving without insurance. I can't remember off the top of my head if that was a conviction or a dismissal. And speaking with Ms. Ziegler, she seems to take the matter seriously and be apologetic. So for those reasons, I offered the delay of sentence. I would recommend some kind of community service so that she can pay back the community for this crime and any other programming that the court.
Is there any restitution request?
There's no restitution, is all recovered.
All right. Ma'am, you had the right to address the court prior to sentencing. Is there anything you'd like me to know?
Can I get some kind of counseling?
Okay.
you like order, you know what I mean? Could you order some kind of counseling for that, please?
Okay.
That's the only thing I have to say. Other than that, I know that I did something I know it was wrong. So I take full responsibility for what I did.
All right. All right, I will follow the recommendation. I think it's appropriate in this case. You don't have any prior convictions. So I will put you on a delay of sentence for 6 months. During that time, you're not violating the law, report is ordered, not leave the state without permission, and keep your employment and contact information current. Because this is a delay of sentence, you are not eligible for early release, so you'll have to complete that full 6 months in order to get the benefit.
Okay.
I'm going to order that there be retail theft programming and counseling and any other programming that your probation officer feels is appropriate.
Okay.
I'm also going to order 14 hours of community service work. There is a $75 Crime Victims' Rights Fund fee, a $50 state minimum fee, $150 fine. Court will waive the court costs. 6 months of probation is $180. 0 days jail with 0 days credit. Any balance that remains unpaid for more than 56 days will have a 20% penalty added to it. I am going to waive that penalty while you're on the delay of sentence, so that'll start ticking after you're done.
Okay.
I'll need you to go out to the front window where you checked in, get a copy of your judgment, make a payment if you're able to, if not, get set up on a payment plan, and then you'll need to go downstairs to district court probation and get signed up for probation.
Okay.
All right?
All right. Thank you so
Thank you.
much.
Good luck.
Thank you.
Appearances counsel.
Nick Burns on behalf of the people.
Hey, police court rep champion on behalf of Richard Fowler, who is standing to my right.
All right, you all may be seated. We are here for a pretrial. Is there any resolution in this matter?
Yes, Your Honor, it's my understanding that the defendant will plead guilty to an added count of jostling. People will dismiss the charge count of domestic violence. There's a kilogrue to time served and fines and costs only.
And it looks like he's got 15 days credit on this case. So, Mr. Champion, is that your understanding of the plea agreement?
It is, Your Honor.
Mr. Fowler, have you heard what the attorneys have said the resolution in this case is?
Yes,
And is that how you wish to resolve it?
yes,
Will you please raise your right hand? Do you solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
yes,
So it's my understanding you'll be pleading guilty to what's essentially an added count 2 of disorderly persons jostling. That is a misdemeanor punishable by up to 90 days in jail and or a fine of $500. In exchange for that, the people will be dismissing the charged offense of domestic violence. That is a 93-day misdemeanor and or a fine of $500. Additionally, there is a Killebrew agreement that you would be sentenced to time served and fines and costs only. Now, do you understand that that's an agreement you have with the prosecutor, not an agreement you have with me? So if I decide that I'm not going to follow that agreement, you would be able to withdraw your plea. Do you understand that?
yes.
All right. I know you were on bond at the time of this offense, but were you on probation or parole?
No,
Do you remember reading and signing an advice of rights form, talk about your rights to an attorney and your rights to a trial?
yes,
Did you understand those rights?
yes,
Most importantly, do you understand that you have a right to a jury trial and that by entering a guilty plea today, you'll be giving up that right and you won't have a trial of any kind?
yes.
Other than the plea agreement, has anybody promised you anything in order to get you to plea?
No,
Has anybody threatened you in any way?
no,
And is it your own free choice to plea today?
yes,
Are counsel aware of any other promises, threats, inducements not made part of the record?
No, Your Honor.
I'm aware of none, Your Honor.
Then to the allegation, Mr. Fowler, that on or about December 17th, 2025 in Cedar Creek Township of Wexford County, how do you plead to added count 2 of disorderly persons jostling?
guilty.
In order to accept that plea, I must have you tell me what it is that makes you guilty. So what happened back on the 17th of December?
Me and my nephew got in an altercation.
Okay. And was that a physical altercation?
Yes,
All right. And would that have disturbed the peace if it were in a public place?
yeah,
All right. And I realize that this is a plea of convenience, so I understand. My understanding is that this happened in a residence. Am I correct on that?
yeah,
All right. Do counsel believe defendants provided a factual basis in which to accept the plea and the court rules have been complied with?
Yes, Your Honor.
Yes, Your Honor.
As does the court, I find the plea is knowing, voluntary, and accurate. Mr. Fowler, I find you guilty of disorderly persons jostling. Pursuant to the plea agreement, the domestic violence case or charge will be dismissed. Are we able to sentence today, Mr. Carnes?
Yes, Your Honor.
Is there any victim input?
No, Your Honor.
Elocution, Mr. Champion?
Your Honor, I would ask the court for minimal fines and costs. The court's aware of all the circumstances of this case involving my client. He's rather short on funds at this particular point in time. So with that, I would ask the court to follow the agreement with minimum fines.
Thank you, Mr. Carnes.
Your Honor, I second that. I just asked the court to follow the agreement. Thank you.
What's alleged to have happened here?
Essentially, both parties were wrestling. They disagreed about who started it, but each had minor injuries, such as like a rough burn, I believe, on the defendant, and some red spots on elbow, I think.
So,
Neither sought medical attention.
I mean, was this a mutual wrestling match or did something start this? What?
The victim was upset over the defendant's use of racial slurs. And then the victim said that the defendant tried to put him in a chokehold. And then there was a wrestling match after that.
Mr. Fowler, you had the right to address the court prior to sentencing. Is there anything you'd like me to know? All right. Mr. Champion, procedurally, where's his case at in circuit court?
It is currently, we just had a pretrial conference earlier this week on this matter. And it's being set out for obvious reasons.
Okay, so there's no resolution yet. All right. All right, the court will follow the Killebrew agreement in sentences, time served, and fines and costs. I believe that's appropriate given the resolution of this case. So there is a jail sentence of 15 days with 15 days credit. There is a $75 crime victims' rights fund fee, $50 state minimum fee. Is a $150 fine. The court will waive the court costs. Attorney fees, Mr. Champion.
I would waive that, especially since there's another case pending.
Will waive the attorney fees pursuant to statute. I believe the defendant's entitled $5 credit for every day he sits. So that brings us to a $75 credit. Mr. Fowler, just a reminder that any balance that remains unpaid for more than 56 days will have a 20% penalty added to that. And then even though I've sentenced you to jail, it's time served, but you do have the right to appeal that decision. If you decided that you wanted to appeal it and could not afford an attorney to assist you, you have 14 days from today's date in which to request the appointment of an attorney. All right, you can go out to the front window where you checked in, get a copy of your judgment, make a payment if you're able to. If not, get set up on a payment plan. All right, thank you.
Thank you.